Good afternoon. My name is Don Vivrette. Welcome to the week 8 of the estate series, It's Your Estate series. Want to go through some items with you at the beginning, and then we will get going and be completely involved in this. So we're going to just have case studies and series review in terms of what all we're going to go on. But I want to add one more thing to it, and that is thank you to all veterans and to their families, because that's very critical today in terms of where we are and what we're doing. And I need to check one thing. Turn that guy off. Okay, sorry. It's very important that we say thank you, and that is very meaningful to all of us in our times that we are in. And so thank you to all veterans and to all of their families, because they suffer as much as anyone serving. Process, as we have talked before, the material for you is at materials at itsyourmoneyandestate.org. It will be there through the spring in terms of where we are and what we're doing. The video will also be there after it has been processed and put up. This is what it will look like when you come in. You can go into either money or estate under the materials tab, and it will take you to the various weeks. As you can see on this first week, the video of that webinar is right there. We made sure we have them on top because there are other videos that might be in here. And there's a lot of articles to go through and take a look at. Pete has done a very good job of making sure you've got all the reading material you might want. On that same screen over to the right, you will see sponsors. These are the various sponsors that we have who are participating with us and have participated in many cases for a long time. And we thank them very much for participating with us and being involved in this series. Today is the 11th of November. It's the last week of the last series. So we're done with money. Incidentally, if you were with us yesterday, you might have noticed we ended rather abruptly. I lost internet connection. And since it's all under my name and my connection, we fell off the screen yesterday and couldn't get back to save it and go on. But luckily we were at the very end. So hopefully that won't happen to us today. Normally we're at the physical locations that you see here. I honestly dearly hope that in the spring we can all be together in person, because to me, I would much rather be looking at your smiling faces than seeing you type questions to us. And that is very important in terms of where we are. In terms of the participating charities, here's the list of all of the charities that we have that are participating with us. Shout out again, last time Chapman, 10-year sponsor, and really appreciate their participation through this whole process in terms of where we are. Normally, we would have nonprofits come in and speak to us at the sessions that we do. We decided this year to do it virtually. So we have recordings from the various charities. What I'm going to do is, with every effort that I can, switch us over to the video, play that, and then we will come back and talk. So let me switch this to this, and yes, I'm still talking to myself.
Hello, Santa Ana Strings. We're very excited to be starting this new season with you. Due to COVID-19, this semester will be conducted through virtual learning.
We were having wonderful lessons at Anderson Elementary, and slam, we got hit with COVID-19. Our class act, Pacific Symphonies, musicians, and leaders produced digital representations of all of these events.
Arts Express is a summer arts immersion program for middle school students presented by Pacific Symphony. In contrast to our in-person program, we fully utilize the power of technology to connect us, and our passionate and dynamic staff and counselors really brought the signature Arts Express magic alive.
In the last 6 months, the Pacific Symphony has had to strategically change its way of engaging with our many diverse audiences. Our educational content has been transformed so that it can be brought to your homes entirely through a virtual experience. Programs such as Class Act, Santa Ana Strings, and our summer camp, Arts Express.
I just wanted to say a huge thank you to Class Act and Pacific Symphony for providing these incredible experiences for our students. I know it means a lot to me as a teacher, and especially, as I said, as a parent, and I'm very proud to say that we are a Class Act school, and I absolutely love everything that Class Act does for us and our community.
We were so excited when we got the email to access the online Class Act events. We made a little family night of it. We did popcorn and had snacks, and we sat on the couch and we watched it together at home. We are so grateful to the Pacific Symphony Orchestra and the Class Act program, because we had a beautiful night of culture and music, and it was right in the comfort of our own home. So thank you so much to the Pacific Symphony Orchestra and Class Act program. We really, really enjoyed our at-home movie night Class Act experience.
Our team has also worked to create virtual content with our classical archive performances, musicians recording content right from their own homes, and newly produced content from musicians playing excerpts from around Orange County. We have Wednesday mixtures with Ben Smolin, our principal flutist, and have partnered with the Pacific Chorale and the American Phil Young Chorus to create an over 200-person video mosaic just for you of America the Beautiful. As we venture into our 2021 season, we're going to continue creating content that can be accessed right from our website to keep you entertained safely with your families and friends at home. We're thankful and excited that you've continued to support the Pacific Symphony, and we look forward to being back together with you in our concert hall. Be safe.
There you go. Pete.
What an introduction.
Whoop, wait, come and go.
Yeah. God, it's so miss going to those concerts of the Pacific Symphony. And you forget that we used to do that on a regular basis before the virus, pretty amazing. The other thing is how they've been able to do everything online. Just doing this program has been a challenge at times with the internet and everything else going on.
Yes.
So I want to echo Don's sentiments about veterans. Thank you, and the family.
Yes.
There's just so many wonderful causes, and money can do so much good. So whether it's the support of the symphony, education, the Heart Association, CHOC, Children's Hospital, we feel honored that they had lent their good name to our workshop series. And a special thank you to them for being sponsors, because we wouldn't be able to do this. Steve, why don't you come up and put your on, and then Don.
While Steve's doing that, I'm going to disappear, because I'm going to be in the background looking at the question and answers that you send in. And I thank Pete for answering a couple of them, I think, while we were doing the other. And so I will pop in when there are questions. Enjoy.
Okay. Bye, Don. God, you still haven't shaved, Don. Steve, why don't you pull up your Ask First form?
Okay, I'll do that.
Okay, yeah. Today, what we're going to be doing is kind of a review and of the 8 weeks, and we'll try to go slow. And then we've had so many questions in the It's Your Estate series. There's no way we can get to all of them, but we will answer each one of them either during the program here or individually online after the session is over with.
And Pete,
yes.
I want to add one thing to that. Several of you, maybe many of you, use anonymous as the name when you send us a question and answer. Very welcome to do that, but I'll be honest, we're not going to answer the question after. We can't send you an email and tell you if we don't know who you are. So yeah. Just let.
And by the way, and we don't use your email for any for-profit or purposes. We keep it close to the vest. We really want you to. This is all about you being educated in this particular area. Okay.
So if you ask questions that you don't think we can cover here, please make sure you give us your name, because then we can get in touch with you. Thank you. Yeah. Bye.
Bye, Don. It's like God coming down and saying a few words and then he disappears.
I always figure, he picked a good picture for himself when he did
Yes, exactly. Okay. You got another master's or other advanced degree, Steve, and I would assume that is your Juris Doctorate.
Correct, which is a law degree. Yep.
Yeah. And where'd you get your law degree from?
From Pepperdine University.
Pepperdine University. And you have 22 years as an estate planning attorney. Does that mean that your focus for the past 22 years is estate planning?
Yes. Yeah, that's the overwhelming, majority of what I do is estate planning related. Yep.
Okay. Talk a little bit about your practice.
So I'd probably say, 80% of what I do is either estate planning, drafting wills, trusts, power of attorneys. A good portion has to do with after a person passes away, helping the family administer and distribute the trust or estate. Do handle a fair amount of trust and estate litigation. So when families aren't getting along after someone passes away, in some cases we do have to go to court to resolve those issues. And then I do have a lot of what I consider kind of small, long-time clients, and they have matters that pop up from time to time, whether it be a real estate transaction or forming a corporation or an LLC. So I do find myself handling a lot of those kind of smaller business and real estate transactions as well. So.
Okay. You're licensed by the state of California.
Correct.
Why is it important for somebody to look you up?
If you go to the State Bar website, you can often find some interesting things about a lawyer. What you're hoping is that you won't find anything interesting, but yes. If you do type in and do a name search, you can, if they have a history of discipline by the State Bar, that will show up. But it also it'll have their address and email, and sometimes if the information they have there doesn't match where they're currently stating they are, can raise some red flags, but mostly just to see if they have any history of discipline for some.
And also whether or not they're licensed in the state of California. I've seen many attorneys here from Nevada and Arizona try to practice in these living trust mills where they charge $500 for an entire estate plan. So
yeah. If the name doesn't pop up, that would mean they're not licensed in California. So
can you scroll down just a little bit on your Ask First form, and you put your client's interest first and compensation. How do you charge? Talk a little bit about that.
Yeah. So for most estate planning services, especially if we're doing a new estate plan for you, we charge a flat fee. In the range of $1,500 to $2,500. I'd say most estate plans for my common clients is closer to $1,500 than $2,500. And then for any other services, my hourly rate is $385 an hour. So, for example, if a client came back to do just a very simple amendment that maybe only took a half hour, an hour, we would just charge on an hourly basis. But for most estate planning services, we can quote a flat fee.
Do you give any kind of initial free consultation either on the phone or in person?
Yeah, I'll admit I don't have an official policy, but yes, I'm happy to have a free initial phone call or meeting. Ultimately, if we meet or talk and either I'm able to resolve your issue over the phone or there just isn't anything that really needs to be done, then there won't be any charge for that.
Okay, once that fee is paid, let's say the $1,500 fee, do you charge additionally for each phone call that you have with the client?
Not typically. I'm going to give the classic lawyer answer. It depends. But if you call, if it's a question about the estate plan that we just prepared, then absolutely not. That would be covered under the fee. If a month later you're doing a refinance on your house and you can't remember how you should title the house, give me a call. We'll be happy to answer that question for you free of charge. So.
Yeah. what I'm seeing a lot these days is that attorneys charging anywhere from $300 to $500 a year to be able to call into the law office to have a question answered. I find that a little ridiculous because individuals such as yourself will take a call if somebody has a question, and if it's easily answered, you're not going to ask for their credit card, I assume.
I won't. I have seen that. I want to say I got even something in my home mail where someone was promoting that kind of service.
I discourage people from doing it. I don't think it's a necessity. There's not that many changes that need to be done unless you have a very dynamic estate. You're not associated with anyone who sells insurance mutual funds where you get something under the table as a payoff, you attorney.
Yeah. We don't sell any financial products or have any. We don't promote any products that I get some sort of compensation for. So
good. And then this is above, you swear under penalty of perjury. And that is not all there is to know about Steve. He's actually really a nice guy. and he's not like your typical Newport Beach attorney. So he's just very down to earth and good guy. So I brought Steve in today to handle the review. Why don't we bring up the outline for today?
Okay. Let me see if I can pull this off here.
And while you're doing that, I'll ask the question. So on your flat fee, I assume that includes a will and a trust and advanced healthcare directive and all of those kinds of things.
Yeah, good question, Don. Yeah, no, it includes what I call, I hate calling it this, but the package. So you'll walk out of there with every document you need. It also includes, as long as you don't come in and have 10 real properties, you got a couple, we'll prepare those deeds for you as well to transfer them to your trust.
Do you know what hole it is at Augusta behind you?
I believe it's the 13th green, the par 5 13. Yeah.
Thank you. That was the question.
I figured that was appropriate this week, given that the Masters is happening.
There you go. Yeah, Steve is a golfer. Okay. The basic documents, we just went through them. The will, the durable power, the advanced healthcare directive, and the living trust. Those are the basic documents. Let's talk a little bit about the will. Why is it usually a pour over will? And what does that mean?
So basically what that means is that if you have any assets that have to go to probate, that your will designates your trust as the beneficiary. So in essence, your will is pouring over any assets that may be subject to probate into your trust, so that your trust is the document that ultimately distributes your entire estate. The hope is that we won't ever need to use your will in most cases, but it's it's attorneys like me kind of having a backup plan just in case. So if there's sometimes there are assets that kind of slip through the cracks and were never transferred to your trust during your lifetime.
So one of the big things that people get confused about all the time is a probate estate. What is a probate estate? Talk a little bit about title.
Yeah, so if you have a trust, or even if you don't, title to your assets is very important. So, whether an asset is titled in your trust or whether an asset is titled jointly or in joint tenancy with another person, or whether your asset has a designated beneficiary upon death can make all the difference in the world as to what happens to that asset at your death. For example, an asset titled in the name of your trust upon your death, it will be distributed by your successor trustee, however your trust says to distribute it. If you have an asset that's just in your individual name at death, it will be distributed pursuant to the terms of your will. And assuming you don't meet an exception to probate, may have to go through the probate court process to have it distributed to your trust.
So if you have assets in your own individual name, how much can you have today in your own individual name in the state of California?
I believe it's 166,500. We get these nice round numbers when these things are indexed for inflation, but
Why they do that, I have
I
no
don't know,
idea.
but
Yeah, but it's actually going through probate, but it's a small estate affidavit that people can use.
yeah. So that exception comes in very handy for smaller assets. Now it only applies to non-real estate assets. So, and then there's another similar exception for basically anything registered with the DMV, like cars, motorcycles, boats, stuff like that. So
They pass outside of the probate code, correct?
correct. You don't have to go to court for those. An attorney can help you prepare the simple form. You have to wait 40 days after the date of death before you can utilize it, but it's a lot better than having to go through the court probate process, which, especially with the current pandemic, can, we're looking at a year and a half, 2 years on some of these probates now.
Yeah. And the executor, if you name an executor and somebody in the will, are they guaranteed that they will serve, or what happens there?
So, there's an important distinction, I think, being named as an executor in the will and actually being appointed as executor by the court. So someone just named in a document really doesn't have any authority to do anything. It's a bit of a misnomer. Once an executor is formally appointed in a probate process is when the executor finally actually has the power to take possession of assets, administer the estate, pay bills and debts of the decedent and so forth.
So it's only the judge really in a probate matter that can change title to assets.
Correct. Yeah, you're not allowed to distribute any of the assets to the beneficiaries until you get a court order from the probate court authorizing the executor to do so.
Yeah. So these estate planning documents, it's all about having the legal authority to act. And does a will, an executor, have any power during a person's lifetime?
No. So, becoming an executor doesn't happen until someone passes away. And then the secondary step of actually being appointed by court order before they have any authority. I'm sure many of the people watching on the webinar will have experienced after someone passes away, you take the will down to the bank or try and deal with someone, say, hey, I'm the executor. And they usually ask you for a document called letters, which is like a court order, appointing you as executor. So what you find is just being named in the will, although it's what you want to do, you want to have a will that names an executor, it doesn't become effective until a court appoints you.
Okay, let's go to the durable power of attorney. First of all, what is it?
So a power of attorney is a document where you appoint someone else to make financial decisions for you, or the ability to enter into financial transactions on your behalf. You can appoint someone with the immediate power, as is noted in the outline there, where, for example, I could appoint Pete as my agent under a power of attorney so that he could sign a document on my behalf right now, even though I still have capacity. Or you can create a power of attorney that doesn't grant that authority to the agent until you become incapacitated. And in most cases, especially where we have a husband and wife, we prefer to use the immediate powers of attorney just to avoid the step of having to get a doctor's or a medical opinion stating incapacity. Those can sometimes be challenging to obtain, but in most cases they're not.
Yeah, usually in the circumstances, especially if you're 80 and over, I would say that if you trust the person enough to name them, make it an immediate durable power of attorney. That way, it's very embarrassing to have to go to a doctor's office to have you declared that you're demented or that you lack capacity just to make decisions. And sometimes it's just a matter of writing a check, or it's not something major. So unless you have a real good reason to want springing, and define springing again, Steve, what is that?
So springing the power doesn't spring to your agent until you become incapacitated.
And with a doctor's letter or that type of thing.
Yeah. So, and as you noted, the challenge can sometimes be getting access to that doctor as well. Mom or dad, or may not be cooperative at the point where you need to use it, or another family member who is not cooperating. So, having the immediate, assuming it's appropriate under the circumstances, is what I typically recommend.
What I put financial institutions, or we put financial institution on the outline. Why is that important?
Many financial institutions, especially the larger ones, are very skittish when it comes to powers of attorney. They don't like it when people try to use them. Many financial institutions, and I know you've noted this in many of your classes, Pete, and they have their own form for a power of attorney that they want you to use. So even if you have a perfectly valid power of attorney drafted by a lawyer, signed and notarized, and even though the law says they have to recognize it, it can sometimes be a real challenge getting a bank or financial institution to recognize it and allow you to act. So it's a good idea, and I know Pete has said this many times, to at a minimum, take your power of attorney to your bank and see if they'll recognize it. And when clients do that, a lot of the time they come back with the bank's form and ask me to help them sign and notarize it. So
yeah, it's I just went to Citibank just the other day, and the same thing happened. Brought over a very legitimate durable power of attorney, and they said, could you please, since you are here with your principal, why don't we complete the Citibank's form? PERS likes to use the same thing. Bank of America has an internal rule that automatically says your durable power of attorney is no good if it's over a year old. Is that true?
They get nervous when they get older. They think that maybe the one you show up with at the bank has been revoked, and you're just not, even though the law provides a lot of protection to the financial institutions when they, rely on what on its face is a valid power of attorney, they still know that if a lawsuit happens, they're going to get named.
And that's what they're concerned about. So
guys, let me ask a question, because we've got a couple of these have come in. One of them, I'm going to read it to you. Is springing or immediate two different forms of durable?
Steve, want to go ahead and answer that?
Yeah, so durable just means that, like, if you sign a power of attorney that appoints an agent, obviously while you have capacity, that your power of attorney actually survives when you do become incapacitated.
So it'll state in the document itself, it says this document will survive incapacity, or it will use the term durable.
It will often use the term durable. It may explain it or define it, but not very. As a practical matter, you never see powers of attorney that aren't durable. I mean, I can't.
Well, I see.
Okay, so I'm going to read the question to you in related to that.
Yeah.
If a power of attorney has the following statement under disability of principal, quote, the durable power of attorney shall not be affected if I become disabled or incapacitated. Is this an immediate power of attorney? Would I still need a letter of incapacity from the doctor?
So the language that you read there, Don, that tells me it's a durable power of attorney, meaning that the power granted will survive incapacity, which is different than whether it's immediate or springing. From the language you read, or at least as I heard it, I can't tell whether it's immediate or springing. If it's a springing power of attorney, it will usually have language in it that says this power of attorney won't become effective until I'm incapacitated, and it will usually have the process for determining incapacity, such as one doctor's letter or two doctor's letters. Immediate usually just reads as if it's granting the power right now. It may not use the words immediate. So, sometimes you, or often you'll see the word springing in the title or somewhere in the power of attorney if it's a springing power of attorney, but not always.
Okay, one more, because you mentioned it in terms of the financial institutions. Do you suggest attorneys have their clients fill out institution-specific forms for their clients?
I'm always happy to assist clients if they want my help filling them out. Most of the time they're pretty straightforward. I'm not here to say you need to, go to your lawyer or pay a lawyer to help you fill out the form. But at least in my case, if you have a quick question, or clients email over those forms all the time, I'll give them my 2 cents as to how to fill them out and so forth.
Thank you.
Yeah, and most of your major financial institutions will help you fill out the form, and it's just that form would just be good for that particular account at that institution. So just remember
Correct.
that.
Yeah. And usually they've got a long checklist of powers, whether you want to grant the agent power to do this or that. I am generally in favor of checking the all the powers box as opposed to limiting. But there might be certain things looking through the power, especially with banks and brokerage houses. They sometimes clients get a little nervous when they've got trading on margin and all these other things that are theoretically a power that so you can be selective or just check it all. Most powers of attorney forms are drafted pretty broadly to really grant the person the power to do anything that you could do if you could do it yourself. So
yeah, that's why you got to be careful as to who you select. And when does it become effective, durable power of attorney?
It becomes effective when you sign it.
Yeah.
It's the day you sign it. So yeah.
Remember, you're given legal authority for the person to act on your behalf. So you want to trust them. And let's say you had a durable power of attorney, but all your assets are titled in the trust. Will the durable power of attorney have access to your trust assets?
In almost every case, no. The way I like to describe it is the trust kind of has a built-in power of attorney, which is the successor trustee provisions that appoint someone to serve in the event you become incapacitated. But the durable power of attorney is what I call, it really only gives them authority over either non-trust assets or financial transactions that aren't trust related. For any trust related transaction, that would be the successor trustee would have to step in the event of incapacity. Kind of a similar function and process as a power of attorney.
Yeah, I call the durable power the poor man's trust sometimes because it has lots of similar powers. But, for hospital bills, insurance, your IRA, your 401k, assets that are not in trust, you need a durable power of attorney. And that's why it's part of that package.
Yeah, there's always going to be something, it might be signing a tax return or, Social Security, which you may have mentioned. I'd say in 95% of the cases that I do estate planning, the person you name as the agent on the power of attorney is the same person you're naming as a successor trustee on your trust. It's typically the same role and function. Yeah.
Let's go to the Advanced Healthcare Directive, the healthcare agent power of attorney. Most of the time that this comes into play for most of us is when we're confronting death. And it's my belief that this is one of the most difficult things for us to deal with. And so speaking of my own family, we never discussed it. And therefore, we didn't really know what mom or dad wanted because it was never just talked about. And lots of assumptions are made by the healthcare agent, and they basically just assume that they know what the other person wants. Do you draft your own advanced healthcare directive, or do you use a pre-printed form, Steve?
I've gone back and forth over the years using, just for the people watching, the Advanced Healthcare Directive it's really a statutory form, meaning you can look up the basic format is in our probate code, but you can customize it however you want. I've got a couple different versions that I've used. Some have a little more detailed description about what they call end of life decisions. But also, just to use an example of myself, I kind of like the simple check the box of the statutory form, given that I want, my agent, my wife, to be able to have the most flexibility to do whatever she thinks, in my case. I mean, I've drafted them where we've got, some, page and a half of instructions that I would challenge anybody to have to implement. But we do, try to do what the client would like and what suits with their intent.
Yeah, I think it's more about your feelings and views and your values, and so whoever is going to be your agent, I recommend highly a bottle of wine and sit down and have an hour's conversation, because both of you are going to die. So even your agent. So the conversation is going to be relevant to both of you, and talk a little bit about it. Read some of the articles that we included even in this session on the materials page. Why do doctors die differently than the rest of us? And remember, it's an industry, and staying alive here in Orange County is not an issue. They're going to keep you alive. And so the other part is allowing you to die is sometimes a bigger problem. And the courts here in Orange County will never, ever approve pulling the plug on a particular individual. And then allow yourself, as you age, to change your mind. We don't think every year the same. So who needs to know that you're changing your mind? And that is your agent. So we have plenty of material on our website. One of our sponsors is the Hemlock Society. So if you want to go that route, you're certainly welcome to. We believe that you're in charge of your own body.
Pete, but to that point, what's a conservatorship?
A conservatorship. Steve, what is a conservatorship? That's a legal question.
Sure. So a conservatorship is someone being appointed either by the court to be able to make financial decisions for you, or to make health and care decisions for you. There's two different kinds. Often they go hand in hand. There's a conservatorship of the estate, which is for financial, and then there's a conservatorship of the person, which is where you get to make medical decisions, care decisions, living decisions, where they live. So a conservatorship is what you may be forced to do, to go to court to get a conservator appointed if you do not have a durable power of attorney or an advanced healthcare directive. Those two documents combined are intended to avoid having the cost and expense and time associated with having to get a conservator appointed by a court, which it's every year you go back to court, do an accounting, do reports back to the judge about your care and medical circumstances. And so not only does the conservator, which is the person who is appointed, have a lawyer, the person who the conservatorship is over, they will get a court-appointed lawyer to look out for. So it starts getting very expensive and time consuming, which in most cases can be avoided if we have a simple power of attorney and a healthcare directive.
Yeah, let's scroll down a little bit. I think we've got some more. Yeah, I highly recommend the Your Way booklet. And it's just about, it's not a test. It's just to begin that conversation. Who should I listen to? Who should I not listen to? If I am unconscious, what do you want me to do? The use of a ventilator today is with the virus. You know, how long do you want to kind of stay on a ventilator? Lots of critical issues. And
those booklets are great, Pete. And also, you know, I recommend to a lot of clients, especially where they're appointing agents who maybe aren't that close to them or know what they want or how they live or who their doctors are, or, you know, all those things is, you know, whatever information, whether you write a letter to them, kind of, you know, look, this is what I want. This is how I want things handled. It can be so helpful to someone who may be stepping into a situation where they're kind of having to figure it out on the fly. And if you can provide a nice little, at least outline of hey, this is who you should talk to. These are my doctors. These are the type of treatments or care I would like to receive. This is where I want to live. I want to be at home or in a nice nursing home. Those kind of things can all be extremely helpful.
Yeah, that conversation is so important. And you'll find out whether or not the agent can follow through on your wishes. You know, sometimes their religion gets in the way, sometimes distance gets in the way, sometimes conflicts of interest get in the way. So to me, the Advanced Healthcare Directive is probably one of the more important documents. And how many individuals is there a limit to how many successors that you can appoint?
No, I'm not aware of any limit. You know, in the power of attorney and the healthcare directive, I would almost always suggest naming at least one backup. You know, I recognize there are many cases. I have clients that there isn't an obvious person, so, you know, we don't. But I try to get them to come up with someone they would trust to make these decisions. Just because what invariably happens is you get an advanced healthcare directive and power of attorney today. You know, in 15 years from now, we're needing it, and maybe the person you name first can no longer act because of death or has moved away, or, you know, all kinds of circumstances that can pop up. So it's nice when you've got an alternative in there.
Yeah, one of the things on the Advanced Healthcare Directive is that when you go into the hospital, you'll have a hospitalist. And when you meet with that hospitalist and say, hey, I'm the healthcare agent for blah, blah, blah. And one of the first things they're going to ask is, well, how long have you known this person? What is your relationship to the person? Have you talked to the individual about what they would like or not want? In other words, they want to kind of find out is that how well do you know this individual? Because a lot of people change their minds in the last 6 months of their life, either to prolong or not to prolong. So and you want that hospitalist to hopefully listen to the healthcare agent, so that the healthcare agent has some credibility. And many a times they go, well, this particular individual hasn't talked to the individual for 5 years. He has no understanding of anything medical. And the doctor, bottom line, is going to be in charge.
Yeah.
Pete, let me back you up to the Your Way book. Do you know the website by heart?
Help4seniors.org. It's HELP, the number 4 SRS.org.
Thank you.
And it's on the materials page, that the address and telephone number for help.
Thank you.
And by the way, that is not a legal document. Okay, it's just a conversation piece. I think it's really important. Let's get into a living trust, one of the mainstays of an estate plan. And I used the term fictitious. I didn't mean to put fictitious in there as that it's not real. But what is a living trust?
Yeah, so, you know, a trust is basically a legal entity created to hold title to your assets and provide instructions for, first, how do you want those assets held and managed during your lifetime? And then, I'd say for what most people think of a trust is what happens to those assets at your death? How do you want them distributed, and so forth? So it's, the typical quote living trust. It just means it's a revocable and amendable trust by the person who creates the trust, so they can make changes. I always like to think of it, a living trust is just a will that avoids probate, but it also, its main difference from a will is it's a legal document, and an entity that holds actual assets the day you sign it, whereas a will only becomes effective upon your death. So in many cases, that's how a successor trustee can step in the event of incapacity. In some cases, we have specific instructions as to how to distribute even while you're still alive. But in most cases, the person or the married couple who creates a trust together, they're often the initial trustees. So, they control everything just as if the way they owned it before during their lifetime. And really the document doesn't become all that important until either we have incapacity and a successor trustee needs to step in, or upon death. And now we're going to be transitioning those assets to the beneficiaries.
If a husband and wife have the trust, if one spouse dies, do you have to redo the trust?
Typically, no. The trust is, at least the trusts I draft, and 99% of those I see, they're drafted in a way so that they cover that eventuality and have instructions and provisions that govern how the trust is to continue after the death of the first spouse. In many cases, the trust will state that it's to divide into a couple trusts, like a survivor's trust or a bypass trust. In some cases, it just says it just continues as one trust. And the surviving spouse may have the ability to amend or revoke all or part of that trust, so we can make changes in most cases, but really there typically isn't a need to create a new one.
A lot of times people talk about living trust as, the reason why you should have one is to avoid probate. And I always like to say is, if that's the reason why you're doing it, you may want your children to pay the attorney's fees because you're going to be dead, so, but it is so much easier to step in and manage another person's estate if they step in as a successor trustee. And it really does most times avoid the conservatorship.
Yeah, it just, for whatever reason, and you have a ton of experience as a professional fiduciary, Pete, but with this, the successor trustee provisions just work way easier than a power of attorney does. And there's no real rational reason why that should be the case, but because they're effectively do the same thing.
Yeah, financial institutions are so much more comfortable with a living trust than they are with the durable power of attorney. And it just works so much nicer. How often should you look at your trust to see whether or not it needs to be changed? Whenever you get a letter from your attorney?
Well, I'll admit I'm remiss on I'm not the guy who writes every year to tell you to call me so I can bill you to tell you need to review your trust. I'm probably not typical, but I'd say every 5 years, or if there's some family event, either a death, a birth, that may affect either a beneficiary or successor trustee. And I'm not saying you need to even go to your lawyer to have him review it, but you should pull it out and read it and make sure that, okay, because it's amazing how many times someone will come in and I'll say, well, this is what your trust says. And then, I didn't know we still had Bob as a successor trustee.
Yeah.
We don't talk to Bob anymore, our old neighbor or friend. So, it's good to take a look at it. And even more importantly, and maybe I'm jumping ahead, Pete, but it's to look at your assets, and how they're titled, and are they in your trust? Are they out of your trust? If they have designated beneficiaries, are they up to date? That I find is often the more problematic issue that needs some updating, even more so than maybe the terms of the trust itself.
Yeah, it's I see beautiful trust written, very clearly stated, and then none of the assets are titled in the name of the trust, and which means if it's over 166,000, we go to probate.
Yeah. And I mean, as I mentioned earlier, I mean, just as an example, as you know, Pete, we had a probate. It's been open for almost a year. The courts were shut down. This is in Orange County. We, file a petition to get the court order we need to distribute the estate to the beneficiaries. I think we filed it in August, and we got a hearing date on that for next June. Just
Wow.
to give you an idea of the backlog that's been created. Orange County was already a problematic and slow court with probates, but with the pandemic, it's gotten even worse. So almost makes it more important to hopefully avoid that process if possible.
So I think two of the most important sections of a living trust are the trustee section and the distribution section. That seems to be the two vital, most important areas. And how do we avoid court if one of our successor trustees dies or moves? And we don't have the documents change. How can we draft a trust in such a way as to avoid going to court, but still appoint a successor?
Yeah, so we can build in some flexibility, especially with successor trustee provisions. A couple common ways. Sometimes we use them both in the same trust. One is we can allow a successor trustee. So, for example, if John Doe is the last person in line as the successor trustee, and he can see that his health is poor, we can give him the power to appoint someone to act after him. And then,
but does it have to be stated in the trust?
It does.
Okay.
Yeah, it does. And we often use these in conjunction if there is a trustee vacancy, meaning every person you've named can't act for, often by reason of death, but could be other reasons. We can give the beneficiaries the ability to appoint a successor trustee. You see a lot of it. I don't use it that much, but a quote trust protector or some third party you can designate to appoint a successor trustee. For example, you give a trusted friend who either doesn't want to act as trustee or you don't think it's a good fit, but you can give him the ability to find and choose a successor trustee in the event one is needed. So we can build in some flexibility that way.
And that avoids the probate court.
Correct, because if you don't have a trustee for your trust, although it's not a full probate like what we were talking about earlier, we do have to file a petition with the probate court to appoint a trustee to fill the vacancies.
Okay. We talked a little bit about distributions.
Pete,
Yes.
Pete, hang on for a minute. There are a couple of questions. And I'm going to read it as is.
Could you scroll down, Steve?
Sure.
Go ahead. Go ahead, Don.
Okay. I understand that if you have a large estate and no trust, you can avoid probate if each financial account has a beneficiary.
Yeah. Do you want me to take that, Pete?
Yeah.
Yeah. That's absolutely true. The trust is not the only way to avoid probate. So, assets that have designated beneficiaries. So if you make sure that every account you have has a designated beneficiary or is in joint tenancy with another person, you can avoid probate. I tell this story from time to time. My wills and trust professor in law school, spends all semester teaching us about wills and trusts and why you use them and so forth, and then said, I don't have a will or a trust. I've got my entire estate set up with payable on death beneficiaries and joint tenancy, which I thought was kind of funny. The professor who taught wills and trusts didn't have a will or a trust, but hopefully he had at least a power of attorney and a healthcare directive to deal with the capacity issues. But
Okay, wait, another question for you. So, I'm sorry,
go ahead.
if I have a savings account with over $200,000 in it and it's not in the trust, will I go to probate?
Yeah, if it's in that person's individual name, it will go to probate. That is correct.
Okay, thank you.
Title.
Yes.
Remember that. How is it held? And if it's over 166,000, it going to probate. If it's in the individual name. I've had individuals who used the POD or paid on death as well, because they just didn't like attorneys. But what if that person dies? What if that it doesn't? It is a very awkward way to manage an estate.
I agree with you, Pete. I
would not recommend it.
I mean, PODs can work great in certain circumstances, but the problem, as you said, unless you are super diligent about keeping those up to date, PODs do not work good if minors, anyone under age 18 is going to be a beneficiary.
If the person dies on the POD, is not around, or is incompetent, or is a spendthrift.
So where's your trust? You can build in, you have provisions typically that account for all these what ifs. What if this person dies before they receive the inheritance? If we have a young beneficiary, do we hold it in trust till they reach a certain age? All those things we can do very nicely in a trust, and you can't on a POD.
Yeah, and the comment was is that this was a fairly large estate, and I've seen this. I'm Dutch, so we're very, very, very penny wise, but this is a penny wise that you shouldn't do. It's just not very competent. You've got if you've got a large estate, you've got $1 million estate, spend $1,500 on an estate plan, because $1,500 is what percentage of $1 million? I'm not a math, but it's tiny.
Yeah,
so,
it's very, and if you have real estate, really a trust is the only good way to pass real estate and avoid probate.
Yeah.
There is such a thing as a payable on death deed, but they come with the same pitfalls and issues that POD designations on an account can have. Now, in most cases, a part of your estate will be by POD. Okay.
Yeah.
And there'll be with that life insurance or IRAs or things like that. But I generally wouldn't use them as your overriding estate plan. Yeah.
Why don't we want to use pay grandchildren directly?
Because if they're under 18, the bigger problem, you actually have to go to court to get a guardian appointed to hold and manage the money until they reach age 18. Again, very much like a conservatorship, you get the costs and expenses, and then they're going to get it at age 18, whether you like it or not. I find that most clients, when they have young beneficiaries, whether it's children or grandchildren, envision them getting it, after college, 25, 30, 35, something like that.
I'm using 55 as the age now today. Yeah. The other thing too is that the use of subtrust. Talk a little bit about that.
Pete, before you do that, I want to stay with grandkids for a moment. There was a question early on, and you talked about this somewhere, or one of the presenters talked about this along the way, of setting up for your grandchildren. You pay them and the money goes into a Roth IRA. So the question is, how young a child should be for grandparents to pay them wages and contribution into a Roth IRA?
Well, I would say they have to have earned income.
Right.
So, I would say probably 10 years old at least, maybe 8. In other words, they have to actually perform work. You actually have to give them a W-2. So there's a few other things involved, but that's really a CPA question.
Okay, gotcha. Thank you.
Subtrust, Steve.
So I think when you use the term subtrust here, Pete, you're just talking about also inheritance that stays in trust for a beneficiary.
Correct.
And there's often, I'll say the most common reason is they're just too young, but there could be irresponsible financially. There could be a beneficiary that has creditor issues. Could be one that has special needs that receives government benefits. There could be beneficiaries that have substance abuse issues, for example, and you want to restrict distributions if that would not be beneficial to that beneficiary. So we can, basically, for example, you have $1 million estate and you got 3 beneficiaries, but one of them has a bunch of creditor issues. One of the ways you can protect that inheritance from creditors is by saying the creditor beneficiary, his share will be held in trust for his lifetime, and the trustee will have pure discretionary distributions over his lifetime, and so that would protect that inheritance from, in many cases,
because they don't own it in their own individual name.
Correct. Now, the courts are pretty aggressive with trying to attach those kind of things. I would never tell a client that anything's 100% foolproof when it comes to that kind of stuff. I've seen it where they pierce what would otherwise seem to be a creditor protected trust, but it can be a great tool for that beneficiary.
And when one of the things is what most individuals don't talk about what their legal counsel is, that the effort and expense that it takes to set up a subtrust.
Correct. So you don't actually create a new document when you create a subtrust. The terms of your trust say how it's to be managed and operated and who's going to be the trustee, but there is an ongoing cost associated with having this continuing subtrust over time. You have accounting fees, trustee fees, legal fees. So what I see a lot is clients want to hold $50,000 in trust till the beneficiary reaches age, we'll use your age, Pete, 55. And it really doesn't make economic sense given the costs associated with it to keep it going. I kind of use as a rule of thumb, and I probably violate it all the time, but if we're not going to have at least $300,000 to $500,000 at least held in a trust for a beneficiary, then we might want to consider an alternative or a quicker distribution to that beneficiary, just because kind of the costs outweigh the benefits.
Yeah, and so when you're reviewing your living trust again, I love that the fact that you said, Steve, it doesn't need an attorney to review it. But check your distributions. You maybe 10 years ago, whom you wanted to give to, they were alive and well and doing super, and now somewhere they've got off the tracks, and you may need to make some changes in your distributions. And if you can't understand how you're distributing your estate, then your attorney hasn't done a very good job in drafting the document. It should be pretty clear.
And I actually see this issue pop up when it comes to pets sometimes. Okay, it's, well, how much do you want to leave your pet? And most of my clients, even if those are wealthy, they're not looking to leave $1 million for the care of their pet over the pet's lifetime. Maybe they want to leave $50,000 or $100,000. And again, if we hold that in trust for your pet's lifetime, the costs are going to eat it up. So I usually say, look, if you trust this person enough who's going to take and care for your pets, why not just leave them a gift? Leave them $50,000 along with your pet, and they'll know that money is intended so that to shelter the costs of of owning and caring for your pet, just as kind of a.
The other thing too, that I see a lot of mistakes made, that a lot of people use specific dollar amounts versus percentages as far as distributions are concerned.
Yeah, no, I encourage every client to use percentages, and I get a lot of pushback just because, and I get it, clients think of their estate in terms of dollar amounts, not as percentages. But I'm perfectly fine with some small specific dollar amount gifts, but when you start getting to the distribution of the heart of your estate, percentages, typically work better. It's amazing how many times, your assets just change over time. And so percentages will work better in kind of changing as your estate does.
Talk a little bit about personal property and a personal property assignment. Talk a little bit about, because you've seen trust administration side of it and you've seen the drafting side of it. How should personal property be handled?
Yeah, so I mean, I've drafted wills and trusts that have the detail down to the Tupperware in the kitchen as to who's going to get it. It's typically not my preference. So, but in most cases, what I advise clients is, or we'll have a provision in the trust that says, your personal effects, your jewelry, furniture, antiques, artwork, will be distributed as you'll put in a separate letter that maybe you sign, or if we have beneficiaries who have a good relationship and we think it's going to be cordial, I leave it equally to my kids and they'll figure it out. And that can work okay as well.
Yeah, I like provisions in the trust that says if they can't figure it out, then the trustee steps in and becomes the dictator and says, just distribute it equally.
Yeah. There's no harm in having that in there. That usually doesn't result in an agreement, though. If the kids don't agree, the trustee will have to be a braver man than I am to step in and do something over the objection. Unfortunately,
personal
that's
property
often,
a lot of times causes more problems than the actual assets. And then you prepare the grand deed to transfer the real property to the beneficiaries if needed. One of the big issues usually is a house, and with Proposition 19 on the ballot, or Proposition 13 being limited, I guess. Any comments on that as far as going forward?
Yeah, so I mean, at least in the context of trust and estates, prior to Prop 19 passing, I don't know if it's official yet, but it looks like it's going to pass if it's.
And just as a note, because we have people around the country, this is a California issue.
Correct. Yeah, so this is just in California. It used to be you could leave real estate, you could leave your house plus $1 million of other real property of assessed value to your kids, and they could keep your property tax value for property tax purposes. So it would avoid reassessment. So Prop 19 has severely restricted the ability to utilize the parent-child exemption from property tax reassessment. And I think that goes into effect early next year. And so there may, if you have this property that's important to transfer to your kids so that they can keep your property tax basis, it might be worth having a conversation with your estate planning attorney whether a gift might be appropriate at this point in time while the law still exists to create that exemption. Basically, they're getting rid of the parent-child exemption unless you leave your house to a kid and your kid is going to use that property as his personal residence.
And there's a limitation of $1 million up value.
Correct. There's limitations on value there. Yeah, I apologize for maybe oversimplifying it, but yeah. So it does add that. I also see it does add some additional property tax benefits to those over age 55 who are going to purchase a new property. used to be you had a one-time ability to carry over your property tax value if you're over 55 to a property that you purchased for equal or lesser value. So now you can do that up to 3 times, and you still get some benefit even if you purchase a house that's of greater value than the one you sold. So.
Let's go scroll up on the outline, please. Taxes. Okay, one of the big benefits your family has of you dying is they receive your assets, and they receive it with a step up in basis, which is huge. So if you bought a stock for $10 and it's now worth $100, and if you were to sell that stock during your lifetime, you would pay a capital gains tax of $90, or on the $90 worth of gain. The step up in basis means this is that $10 cost basis that you had in the Apple stock goes to market value of 100. And when you sell that Apple stock at 100, there's no gain, because all assets upon death receive a step up in basis except for IRD assets. And it's explained in the second bullet point: income in respect of the decedent, commercial annuities, IRAs, 401k, SEP IRAs, 457 plans. These plans are perfect if you're going to if you have an inclination to give to a charity, because a charity doesn't pay any taxes whatsoever. Do you think they'll eliminate the step up in basis benefit, Steve, in going forward?
I don't claim to be a pundit. Who knows? It always, whether it's clients or other people who claim to be in the know, always seem to think that these gift and estate tax rules and step up in basis are going to change. And what I always like to remind them is, most members of Congress, no matter what side of the aisle they're on, are very wealthy, have large estates, and they want to pass those benefits on to their children. So, over time, whether through both Democratic and Republican presidents and Congress, the estate tax exemptions have continued to increase over the last 20 plus years. So it would not surprise me if the step up in basis just stays very similar to the way it is now.
It used to be where 10 plus years ago, where married couples did an A-B trust for tax purposes. Is that still relevant today for tax purpose?
Wait, before you go into that one, Steve, there's a question.
Sure.
So we talk about step up, and Pete, you had made the comment that, your house and all these other assets. But if it's in joint tenants, then I only believe half of it goes up, correct?
Technically, yes.
Right.
But I would always take an aggressive stance and say, hey, we just kept it in joint tenancy for convenience, and it's really community property if you're married, and then see whether or not the IRS comes back at you.
Which sort of takes you to the AB trust, because if you put assets in the B trust, when the second dies, you're not going to get step up on the B trust.
On the second to die.
Second to die, right.
Yes.
Okay,
Yeah,
sorry, Steve.
No, I agree with Pete. I mean, for step up and basis purposes, we would prefer to have assets titled either in your trust or as community property, because there is a technicality in the rule. If it's joint tenancy, only half of the asset gets a step up in basis on the death of the first spouse. But I would also take an aggressive position, even if that was the case, like Pete mentioned there. To get back to your question, Pete, about an AB trust, we don't need an AB trust anymore to save estate taxes. So the rules have changed, and that's regardless of how large the estate tax exemption is. It's a common thing kind of described as portability. So that's gotten rid of our need to have an AB trust. Sometimes there's blended families or other reasons why an AB trust can make sense in a particular case, but we don't need it for estate tax savings.
It's becoming more and more important that for the client to disclose the family dynamics. you know, who would be the good trustee, so you can help them out as to maybe who to pick. If a sub-trust is needed for a special needs or somebody has substance abuse, you need to know about this. And by the way, you know, every family, the larger your family is, the more likelihood is that you're going to reflect society, that one child or maybe two children need some extra help. And don't be ashamed about that. It happens to good parents, and the attorney is there to help you put this together. Because if you give a child who has substance abuse or is a spendaholic all the money, it's just like giving them, you're not doing the best what's for them.
Yeah, no, I agree. Yep.
Yeah, it's just trust are there to help your family, and not just about, you know, for the attorney to earn some bucks.
Yeah, and one other thing about step up in basis, and it doesn't come up very often, at least not in Southern California or Orange County, because real estate always seems to go up, but it also could be a step down in basis. So I had a few clients during the last real estate downturn that said, oh, I thought it was step up only. No, if your assets go down in value, you actually get a new basis that's lower than maybe what you paid for it. So
yeah, we're not going to go too much into charity, but if you're 70 and a half or over, please make your donations, direct donations to the charity. It's just, you don't have to report it in as income. Charitable remainder trust, you want to go scroll up a little bit there, Steve. They're wonderful tools if you have a low cost basis asset with a high appreciation. It's very worthwhile to run the numbers to see whether or not it is something that you may want to consider. Most attorneys do not draft charitable remainder trust. And I've seen many attorneys that, oh, you shouldn't do a charitable remainder trust. You should just leave it to your children outright. So go to a specialist, somebody like Dawn or one of the charitable organizations, ask for a gift illustration, and then they can help you with the attorney to set up a charitable remainder trust. In your lifetime as an attorney, how many charitable remainder trusts have you drafted, Steve?
Probably 2, and those were done a long time ago.
Yeah. They don't happen that often. So,
as you mentioned, you know, especially larger charities, they have great plan giving departments.
Yes.
They're willing to get involved, and they even help the lawyer, you know, come up with the plan and the documents and
it's not
crunch the numbers.
Yeah. Don't exclude them. It's just that they just don't know how, because they don't see them enough. Charitable gift annuities, they're a fixed income instrument, 2-page. You don't need an attorney. The income is guaranteed by all the resources of the charity or the community foundation. Wonderful little tool if you're planning on giving to a charity to begin with. If you have money in an IRA account, you can't do a charitable gift annuity directly. You first have to take it into income, and then you could do the charitable gift annuity.
Unless it's testamentary.
Yeah, unless it's testamentary. You can. I've seen these used for caregivers, special friends, and they get a check from you for the rest of their life. Every quarter, they remember you. And it, you know, for 10, 20,000, 30,000 to get a little bit of an income on an annual basis is wonderful. And the charity benefits at the end.
Pete and Steve, a question on step-up basis. We have date of death. Can you also go 6 months out?
On step up in basis, I don't know. Steve, can you?
Well, yeah, I think
you can try. You might lose.
Maybe, yeah. It's usually.
I think you can use the alternate value. I think you can use the alternate valuation date, which is 6 months after the date of death,
for estate and gift tax evaluation. Right. I just don't know if you could use it for step up.
Yeah.
My guess is that's what also applies to the step up. But the problem that, at least when my clients always want to utilize that, is you have to do it for all your assets. You can't pick and choose. So, usually what's happening is like one's gone up more or less. And most of the times when I end up spending a lot of time crunching the numbers, it kind of all evens out. Some have gone up, some have gone down. So we don't come out that far ahead.
But it's an important benefit. Iris, how much time do you usually spend on people's beneficiary designation forms?
Not a lot. I mean, we spend a lot of time talking about them and who they should designate. And, every once in a while they'll bring in the actual form itself, but they're usually pretty straightforward to fill out once we've made that decision. Yeah. Usually we spend more time talking about the beneficiary designations if they've got minor children and okay. How to handle that. Okay. Whether your trust should be the beneficiary.
Let's scroll down.
Pardon, Pete?
Let's scroll.
Oh, sorry.
IRD assets, commercial annuities are horrible to pass on to beneficiaries because whatever you have built in is going to be taxed at ordinary income tax at your heirs' rate. Whatever they've earned in that particular year, it gets added to. The same thing with the regular IRA account as well. I make sure with your financial institution that they have the appropriate, correct beneficiary designation form on file. With all the mergers and everything else, lots of them have been lost. So, and yeah, plus, go ahead.
Yeah, no, I agree. It's important to get that. It would be nice to have a piece of paper that says it from the financial institution. Yeah. Sometimes you just call them and they go, I went on my computer and it says what you want. But yeah, I've run into a couple of situations where they can't find a beneficiary designation when we think there should have been one.
Yeah. And they will send you a letter verifying those designations. Okay. Organizing your assets.
No. Let's go through a few questions since this is our last session. Okay.
Okay.
So these are some random questions along the way. If I have a durable power of attorney for finance and it's active, can they change the beneficiary on my IRA?
Most likely, yes. Assuming, it depends on the powers granted in the power of attorney itself. But at least on its face, they will have access to your IRA and can fill out the form and sign it on your behalf. There are some probate codes that limit the ability to change beneficiaries using a power of attorney. I don't know off the top of my head whether that applies to a POD on an IRA or not. I don't recall.
I've tried to do that with a Schwab account, and Schwab required that the power of attorney language stated explicitly in the power of attorney that I had the right to change the beneficiary.
Yeah, that doesn't surprise me that Schwab would want that. Whether or not that's legally required, again, we run into the financial institution has their own rules that we're kind of subject to and forced to comply with. But yeah, it may be the case. But and power of attorneys are kind of all over the map. They're not all created equal when it comes to specific provisions like the ability to change a beneficiary. We run into it from time to time. Can the agent on my power of attorney amend my trust, for example? And number one, can they amend my trust to maybe add a successor trustee? Can they amend my trust to change the beneficiaries, for example? And there are statutes that kind of govern your ability to do that. And it is very important in those cases what the power of attorney says.
Let's go to the next question, Don.
So now we have all these nifty documents. What the heck should I do with them? Where should I put them?
I say put them on a cabinet in your house. I've never heard anyone trying to steal your estate planning documents, and please don't put them in your safety deposit box.
And should I discuss it with my children?
You and I.
And should I discuss it with my children?
You and I, Pete, have always agreed on this one.
Yeah.
I still didn't hear you, Don. I'm sorry.
And should I communicate all of this with my children?
That's really an individual family thing. I've recommended both and I've been wrong.
Yeah, I agree with Pete. I'd say you definitely don't have to tell anyone or share your documents with them, but whoever is named as your successor trustee or who's going to be involved in either after your death or in the event, you want to let them know where they can find your documents. And to go back to what Pete said, I've always agreed with him on this one. You really don't want to put your documents in a safe or a safe deposit box. You want to put them in a place where someone can easily find them.
Yeah.
So
Next question.
now that we've had all this discussion about all this stuff, what's the website where I can check on a license for an estate planning attorney?
The Bar Association.
So if you type in, at least for California, State Bar of California, it'll pop up. I don't have the exact website. And then there should be a place to click for lawyer lookup or something like that.
Yeah, and I'll
You
just put it
type
in
in
their
the
name.
name. It'll pop up.
There's a lot of questions about an inherited IRA. If it's an inherited IRA, are those treated just like a normal IRA?
I'll let you take this one, Pete.
Depends
I
on,
was about to say you.
it depends on their age. So the inherit it's if you're over 70 and a half, you're just going to be mandated to take out a specific amount based on the tables from the inherited IRA table.
And that's probably 72 now.
Okay, 72 now. Yeah, that's all. That's the only difference.
Right. Yeah. Okay. Those are really, there's some other very specific questions that I think we'll have to answer later on because they're a bit more complicated. So that's where I am. So
Okay.
now if you want to thank everybody or for the next 2 minutes.
I show on the clock that we have about 3 more minutes left.
Yep.
Do we? Okay, quickly. Organize your assets. List your assets, title it, give it the cost basis, make the market value. If I were to sell this particular house that's in a living trust, each one of us has a $250,000 credit. I could figure out pretty much what my capital gains tax is going to be fairly quickly. And if I become incapacitated, I know that my successor trustee can step in. Apple stock, gosh, joint tenancy, and the person has a living trust, transfer that stock into the living trust. And I probably would not give that stock away during lifetime. I would probably wait to get the step up in basis. Steve, would you agree with that?
Yeah, I agree. We generally we don't want to gift away low basis property. We'd rather you die owning it so you get the benefit of that step up in basis.
Yeah. Yeah. Inherited bank accounts. Remember, when you inherit monies, is inherited funds community property or separate property?
Separate property.
So if you have it, fee means in the person's own name. So if you get a bank account and you put it in your own name, will that $300,000 now go through probate if you don't have a POD?
Yeah, it will. So when you inherit an asset, it's important to think about, do I need to put this asset in my trust? Or if it's separate property, do I want to create another trust to hold my separate property? Something, those are the kind of things you should think about.
Okay. Do spouses ever, married couples here in California, is there ever a need for a probate if all they have is community property and they have no documents?
It's kind of, I'll say yes and no. There's a short form probate process called a spousal property petition that we can utilize, but you still have to go to court. It just doesn't take as long typically to get from start to finish. It's a little less expensive.
Gifting. Before she died, the 80-year-old wanted to make a $50,000 gift to her children. What asset would she use and why? And what is the amount of the gift tax, Steve?
So the gift tax would be zero because you have $11.5 million exemption, including a $15,000 per year exemption as well. In this case, I would give cash just because the house and the Apple stock are very low basis. So I would just write checks out of the inherited bank account.
Yeah. And so all she would have to do is make sure she files a gift tax return in the year that she makes that $50,000 cash gift.
Yeah, if she makes more, if she gives more than 15,000 to any individual beneficiary, she is supposed to file a return showing zero tax due. But
And the last issue here is what I see one of the biggest problems in estate planning is that one child is a trustee for another child. And it just doesn't work out normally because all they're going to talk about is money and why aren't you giving me more? So do not put other children as a trustee for another child. Most times it just doesn't seem to work.
yeah, it puts them in a very uncomfortable situation of one child controlling the purse strings over another.
Yeah.
And if they have otherwise a good relationship, that can put a lot of strain on it.
That's it, Don. Steve, thank you.
Well, thank you for having me, Peter and Don.
Steve, stop sharing your screen. The red button at the top.
Hey.
Yes, thank you, Steve. Thank you, Pete. This is the last session. I thank you and Pete and all the presenters we've had before. I put up the sunset behind us because Pete always likes to say it's 5 o'clock somewhere, and this is our last of 16 sessions, and we actually got through this one without being disconnected. So
I think it's cocktail hour,
I
Don.
think it's something somewhere. Yes. Thank you, Steve. Thank you, Pete. And
thank you, participants. And we'll try to get to your questions as long as you have an email address, and we'll try to do it within the next week. So don't expect it immediately because we'll be drinking wine.
thank you. I'm going to turn off the recording.